Hello, this is Michael Brown with Avalon Risk Management, your premier provider of insurance and surety solutions for the transportation industry. In our last episode, we concluded our discussion of the exemptions to the requirement to become registered and bonded as a transportation broker or surface freight forwarder. We learned that most companies that arrange for interstate transportation for compensation by truck need to be registered and bonded. Given the penalty provisions in MAP-21 for operating without the proper authority, those that are not registered need to apply for authority immediately. Today we will discuss another important component of MAP-21, the changes it makes to the financial responsibility requirements for transportation brokers and surface freight forwarders. MAP-21, as well as agency rules, required that all transportation brokers and surface freight forwarders obtain evidence of financial responsibility in the amount of $75,000 by October 1, 2013. This is an increase from the previous $10,000 requirement for brokers and a brand new requirement for forwarders, as they did not previously require a bond. The financial responsibility requirement may be met by obtaining either a BMC 84 surety bond or a BMC 85 trust. As with customs and OTI bonds, BMC 84 bonds can only be written by sureties approved by the U.S. Department of Treasury. BMC 85 trusts, on the other hand, require the broker or forwarder to post $75,000 in the form of cash or a letter of credit. They can be a viable option for those who don't mind tying up these funds, but most brokers and forwarders will opt for the liquidity provided by the bond instead. The process of obtaining a bond is simple. Just contact your Avalon representative for assistance. There are a few important points regarding the October 1st deadline. First, it was self-implementing. Its non-discretionary nature did not require that the agency complete a notice and comment rulemaking process like some other parts of the law. The agency did, however, publish a final rule that reiterated the financial responsibility requirements. Second, the FMCSA has announced a 60-day grace period relating to agency enforcement. This does not change the date that the higher bond amount was required. It simply means that the FMCSA won't issue fines or revoke authority during the 60-day period. They did this to give bond and trust providers time to file electronic evidence of the new financial security amount because the agency's system wasn't ready to accept these until October 1st. While today those without a $75,000 bond or trust are not being penalized by the agency, they are in violation of the law and face the potential of civil actions from private parties. Finally, it takes the FMCSA 30 days to revoke a broker or forwarder's authority. As such, the agency has indicated that they will mail 30-day notices of revocation to those who have not increased their amount of financial responsibility by November 1, 2013. This will allow the FMCSA to revoke these companies' authority on December 1st, which coincides with the end of the 60-day grace period. A revocation is a serious matter. It stays on a broker or forwarder's public record on the FMCSA's website forever for any shipper or carrier to view. Now that the October 1st deadline has passed, it's more important than ever that those transportation brokers and surface freight forwarders who don't already have the $75,000 bond obtain one immediately. For more information, contact your Avalon representative. We're here to help. In the last few episodes, we've talked about the need for brokers and forwarders to be registered and have the proper evidence of financial responsibility. We also discussed the definition of a transportation broker, as well as their arranger or travel agent for domestic freight status in some detail. In our next episode, we will discuss surface freight forwarders and how they differ from brokers. Thanks for watching.